since, God, I don't want to say how long. Actually, I joined your organization when I was a first-year law student here in 1982, which is, what, 38 years ago? Oh, my God.
Mm-hmm.
Okay. International legal research. I could go on for hours, and you don't want me to. You really, really don't. So I will just do it quickly. Yeah, it's not going to happen in an hour. We'll take a quick tour of the high points and focus on anything you want to know more about. You got questions? Ask them. And at the end, we'll have time for even more questions if you want. But don't worry about interrupting me. If I'm not paying attention to one part of the room or something, yell at me. Because it's really weird. I've got people over here, and I've got people over here, and there's no one in the middle. Okay, place to start. This is my website, because I don't like the law school and the university's websites. I don't have enough editorial control. So I made my own. This is for my seminar in international courts. There's a login, a user login. You don't need to worry about that. That's for people who are in my class so that they can post stuff. You don't need it. You can just use it. There are some things that are important up here. This does not work. Okay, I do not have a pointer. The tabs across the top, the important ones are the research tab, which gives you this list of research stuff, which I'll talk about more in a minute, and the lecture notes tab. These slides I have posted, I did it just a few minutes ago, on the lecture notes. If you click on the lecture notes, you'll see them there in PowerPoint or PDF. The PDF is smaller in terms of download size, just so you don't have to take a lot of notes on the slides. The research links are basically everything I use. It's mainly for me. Everything that I use in my research, and some quirky stuff at the bottom. It's there because, do you guys know about the proxy server? A few people, maybe some blank looks? Okay. We pay for a lot of databases, hundreds of databases. We pay a lot of money for them. We can't let them out to the whole world, so you have to be usually in the building, right, to use them. If you're not in the building and you want to use them, if you go through the library's website, right, it takes you to the proxy server, you sign in using your MyWCL username and password, and it's like you're in the building. Okay? All of my links have that proxy server built in, if they're a link to a paid database. So you can use this without worrying too much about that. It's internationalcourts.net. Really should have gone through these as I went through. Okay, one of my favorite resources, probably the most important resource for people who are starting off in international law, is the Max Planck Encyclopedia of Public International Law. I have it linked off my page. We have it linked off of the A to Z list. The database is A to Z. It's either under E or M. They keep changing it on me. The title, I mean, it is the Max Planck Encyclopedia, because it's part of the Max Planck Institutes in Germany, the physicists. And they've got a lot of different topical areas. One of them is international law, and they've created this encyclopedia. It's 1,600, I think, last time I checked, individual articles. They're on everything to do with international law. They're long enough to be useful and short enough to actually be readable. At the end, each entry has a bibliography. Bibliographies are your friends. It gives you sources. You can then look at those sources and look at their bibliographies and their footnotes and expand your research. It's a great way to do basic research. Also, if you ever had to read a decision of the International Court of Justice or its predecessor, the Permanent Court of International Arbitration, or some of the older arbitrations, you know just how horrible they are to read. And to be honest, it's not their fault. They only publish in English and French. You pick one, judge gets to pick one or the other. Not all the judges have English or French as their first language, so they pick one that they know. So if the one that they pick, say it's the Russian judge, and he knows French, he's writing as a Russian speaker in French, which then gets translated into English, which is what you read. This is not a recipe for effortless prose, shall we say. So the encyclopedia has an article on every single decision that describes it, gives the background, explains everything, and there's the pizza. Please get up and go have pizza. Explains everything you need to know about the article and gives you sources on it. So it's really, 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 really useful, and I highly recommend it. Okay, before we begin, you do not have to know Latin to do international law, but it does help. I had a retired Jesuit teach it to me in high school, and it's stuck with me ever since. It's drilled in. Hopefully you have not had to have that. But if you run across terms you don't understand, just ask. There's no shame in asking. Some of us have been doing this for 40 years. We kind of internalize things and we forget that other people don't know. When we say consuetudo, they don't know really what we mean. And, it's okay to ask. That's what we're here for. All right, we'll get a little bit more into that when we get into custom. What is international law? Article 38 of the statute of the ICJ is what everybody cites to. Right? Article 38 is the big one. Actually, it's the same article number in the PCIJ statute going back to 1920. It only binds, technically, parties before the court. That's really all it officially binds. But everyone, and I do mean everyone, has agreed that it is the best, clearest, most concise statement of what international law actually is. And so everybody cites to this. It breaks things down into two types of sources, primary sources and secondary sources. The primary sources are the important ones. Treaties, you all know what a treaty is. Custom, which we'll talk about, and general principles of law. That's it. Those are the three sources of international law. If the norm you're trying to prove isn't one of those, it's not a norm of international law. It has to be one of the three. Now you notice we're all common law lawyers here, right? Do we have anybody who's a civil lawyer? We're all JDs? So okay, everybody's a common law lawyer. When I teach my class, I've got about half and half, civil and common. So for those of us who are common law lawyers, there's one thing that's really missing here. Judicial opinions. They're not a source of international law, a primary source. They're just not. And if you're a civil law lawyer, you look at this and the one thing that's missing are learned treatises, right? Because that's how you understand civil law. You use a lot of learned treatises. So that's why there are secondary sources in the statute. Judicial opinions and the teachings of the most highly qualified publicists. This is really important. Those things are not primary sources. You can have an ICJ case that says, this is a jus cogens norm, which we'll talk about in just a minute, or this is a norm of international law. And that's fine. That's the ICJ's opinion. That doesn't make it a norm. What makes it a norm is if the ICJ has, whoa, nice. If the ICJ has said, we find this to be a customary norm, and here is why, and then they list out the reasons for customary international law, what this norm is at. It's used as evidence of the existence of the primary norm. That's all judicial opinions and treatises are. And when I have judged Jessup for 35 years, actually longer than I was on the team back in the 80s. One of the big mistakes in Jessup is, where you're arguing international law, is they will say, this is a customary norm, and the judge will say, what's your basis for that? And they'll say, Ian Brownlee in his treatise on international law said it was. It's like, you just lost. You just lost points. Because that's not Ian Brownlee, it's just Ian Brownlee. It's his opinion. Now, if Ian Brownlee has gone through and looked at a bunch of stuff, that's different. We'll talk about that in a minute. So let's first talking about treaties, right? There's a treaty, and this is actually how they're still done, by the way. They're printed on vellum, or usually printed on vellum. They're bound with holes, and there's a ribbon running through all the pages. And then the ribbon each end of the ribbon is sealed with a wax seal. It's still done that way. That's the official copy of, that is the Treaty of European Union. That's the Treaty of Rome. Or European Economic Union, the Treaty of Rome. That's what it was with all their signatures and everybody's seals. Most important thing about a treaty, what makes it a treaty, is the intent to be bound. If you do not have the intent to be bound, you just have a political commitment. It may call itself a treaty, but if there's no intent, it's not a treaty. There are two basic kinds of treaties, bilateral and multilateral. We'll go into what those are. There are two other basic kinds of treaties. It's fun that way. Regular and simplified. And we'll talk about that distinction too. Start with bilateral versus multilateral. Bilateral, basic treaties, right? Two entities, usually nation states. The US and Mexico have an extradition treaty. That's a treaty. That's a bilateral treaty between the two states. It must be signed and ratified, signed by whoever has authority in each country to sign it, and ratified by whoever has ratification authority. Multilateral treaties are more complex. They're between 3 or more entities. Usually nation states, sometimes international organizations. They must be signed and ratified, just like a treaty, but they require a depository. You guys know what a depository is? Most people don't, I don't think. Okay, a depository. With 2 nation states, or a simple treaty, with a bilateral treaty, you've got your document, you've got a copy of the treaty, you sign it. The other party has a copy of the treaty, they sign it. You exchange the copies and sign the other. So everybody, both parties have a signed, sealed wax thingy of the official copy of the treaty. They then take it home to their archives. And then when it's ratified, the instrument of ratification gets sent to the other party so that they know that you have ratified it. It's fairly simple to keep track of. When you've got something like, I don't know, the UN Charter with 190-some parties, that becomes a nightmare, right? You can't really do that. So you have a depository power. Usually in the old days, it was the country that called it, or who called the convention, or who was the biggest power usually. I mean, like the Hague Conventions, 1899 and 1905, were called, actually they were called by the Tsar of Russia, but they were held in The Hague. The Queen of the Netherlands was the host. And so The Hague, the Netherlands government became the depository power. Everybody deposits things with them, they put them in their archives. We're the depository for the Pan-American Union Treaty and for some of the OAS treaties. We're the depository for those. Once we had international organizations like the League of Nations, and the first main things it did was it became a depository. All the League of Nations treaties were deposited with them in Geneva. They're now in New York. The UN is a depository. The OAS is a depository. The EU, the Council of Europe, the African Union. There are tons of depositories out there. Okay, let's talk about regular versus simplified treaties. Regular treaties are what you think of when you think of as a treaty, right? In the US, the diplomats negotiate them, the president signs them, the Senate gives advice and consent to ratification, and the president ratifies. Now, a lot of times, civics classes and government classes in high school and college, and sometimes even law school, get that wrong. They often say that the Senate and the president signs the treaty, negotiates and signs, and the Senate ratifies. The Senate does not ratify the treaty. Ratification is a formal legal step, and it is done by the president as he or she proclaims the treaty. It does not become law in the United States under Article 6 of the Constitution until the president proclaims the treaty in an official proclamation with the Great Seal of the United States in wax on the bottom. Yes, it has to have all of that. And it's actually the Secretary of State's primary job is to keep the Great Seal. This is the first job they ever gave him. So that's what they do. They put the big thing on it. So that's what you need to get a treaty in the U.S., right? The Senate just gives advice and consent. They report it out saying, we agree, 2/3 of us present agree this should be a treaty, and here's all the reservations we want. That's that. In other treaties, other countries, it's a similar process. Whoever the executive negotiates and signs, and the legislature or some process ratifies. Simplified treaties are different. We call them executive agreements in this country. They're informal or more informal. They just need to be signed. They don't have to be ratified. They are binding obligations, unlike political commitments. So you have to have an intent to be bound. Very important. Simplified treaties can be formal written agreements, which is what the President of the United States is signing at this particular photograph. They can be exchanges of notes, and I'll show you the diplomatic notes between countries. I'll show you one of those in just a minute. They can be exchanges of signals on the high seas between allies. Off of Trafalgar, the French, the British and the Spanish fleets exchanged signals, and that was considered a binding agreement. This is what an exchange of notes looks like. This, you can't really read it from back there. but it's the Embassy of the United States presents its compliments to the Ministry of Foreign Affairs of the Republic of Azerbaijan and has the honor to refer to earlier blah, 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 blah. Yeah, I love these. These official things. Anything from the State Department. There's a paragraph at the beginning that's full of all this wonderful flowery language, and there's one at the end that does the same, and they're all that way. In this case, they're proposing an agreement on the furnishing of defense articles and mutual defense stuff, military aid and advisors back and forth. So they'll have, because you want to set up things, if you're going to have people in other people's countries, you want to set up the liabilities and everything else. So this is what it looks like. At the end, it says, read this off, it says, a diplomatic note from the Ministry of Foreign Affairs stating that the foregoing points are acceptable to the government of the Republic of Azerbaijan shall, together with this note, constitute an agreement. The Embassy of the United States avails itself of the opportunity to renew to the Ministry of Foreign Affairs assurances of the highest consideration. So that's our part. It was replied to by the Ministry of Foreign Affairs of the Republic of Azerbaijan. This is a translation because obviously they replied in Russian, I think. I'm not sure. I think it was in Russian. Urgent. The Ministry of Foreign Affairs of the Republic of Azerbaijan expresses its respect to the Embassy of the United States and has the honor to communicate the following. And they basically say, yeah, we agree, except you got our country's name wrong. It happens. We're the Republic. The replacement of the phrase Republic of Azerbaijan with the phrase the government of the Republic of Azerbaijan. All right, whatever. That becomes a binding treaty or binding agreement. So U.S. executive agreements. This is where we go into con law. This has nothing really to do with international law. This is constitutional law inside the United States. We divide them in the U.S. into three types. Sole executive agreements, treaty-based executive agreements, and congressional executive agreements. We'll talk about each of those. Sole executive agreements. These are made by the president on the basis of the president's inherent authority as the president. The foreign affairs power. Commander-in-chief of the armed services. Those are the powers we're talking about here primarily. To recognize foreign governments. The president can do that. Congress has no say. Armistice and ceasefire agreements on the field. The Korean armistice was done that way. Settle claims with foreign governments. We've had a lot of disagreements with Mexico. We've had disagreements with Bolivia. We've had disagreements throughout the years. With Great Britain during the Civil War. All of those were settled by executive agreement. We agreed to to whatever the settlement agreement was. And then treaty term agreements. When you're negotiating a treaty, a formal regular treaty, when you come to a point where you've got the terms all locked down and you're sending it back to your respective governments to go over and look at the final language before the president or whoever gets to sign it, that agreement on the terms is actually an executive agreement, and it's binding. It says we are going to honor this as the actual text of the treaty. So that's all. Those are all fairly straightforward. Treaty-based executive agreements are agreements made by the president that he doesn't have authority to do on his own, but he has been granted authority, either implicitly or explicitly, by a treaty that has been ratified, an actual treaty, a regular treaty that has been ratified. Examples are like status of forces agreements for NATO. When we put troops in a foreign country, we have a status of forces agreement. That status of forces agreement sets out, if a tank on maneuvers runs over somebody's garden, who pays? That happens in Germany all the time. Knocks over a fence. Who pays? How does all this structure? You don't want to do that in the treaty. It'd be too complicated. A private off base gets caught with drugs. I know that's never happened, right? But it happens all the time. Military folks get caught with drugs. They get caught breaking local laws. How do you handle that? Who tries them? Is it tried in the U.S.? Are they tried by the Army or the Air Force or whoever it is under the Uniform Code of Military Justice, or are they handled in the local courts? That's all agreed to ahead of time in the Status of Forces Agreement. Now, because it's a treaty, gives that power. It's inherent, gives the power to the president to do that. Other things where there's no treaty, like when we were in Iraq and doing status of troops in Iraq, there was no treaty involved. Those had to be run through Congress because the president didn't have the authority on their own and there was no treaty. Okay, other ones. Scientific detail and environmental treaties, like the Rio Treaty and a few other, where you're setting specific limits for pollutants, that kind of thing. You don't want to be negotiating those. You want them to be able to change as scientific consensus changes. So that's usually done in one of these. And details about treaty implementation, like, how we're going to implement this treaty that we've all agreed to. Okay, congressional executive agreements are the vast majority of executive agreements. After INS v. Chadha, which you probably had in con law, that happened when I was in law school. It screwed everything up. A number of professors who were complaining about having to redo their notes was amazing. The vast majority, after INS v. Chadha, you have to go through. You have to fulfill the presentment clause. You have to have the president agree to it, Congress agree to it, and it has to be. Then the president has to sign. It has to be basically a law, a statute. All of the trade agreements that this country has are congressional executive agreements. NAFTA, USMCA, whatever the hell they're calling it now, WTO, GATT, FTAs, the free trade agreements, they're all congressional executive agreements. And when you go looking for them, free trade agreements are really hard to find. I mean, where do you think you go to look for a treaty? You go to the State Department, right? To the Office of Treaty Affairs. They have all the treaties. They have all the treaties except for the free trade agreements because there's something called the Office of the United States Trade Representative, which is another executive office. And there has been, to use impolite words, a pissing match since the creation of that office over who controls these. And State Department says, we're the State Department, you should be with us, they should be in our files. And Trade Rep says, nope, they're ours. And so try to find a copy of NAFTA. I dare you. A legitimate copy. The Trade Rep refers you to NAFTA's website. So there's that. The president must sign or have a veto overridden. Okay, so now that we know what they are, how do we find them? That's a good question. Important caveat, this presentation assumes you need to find things for an academic purpose, not for litigation. Litigation is different, much more complex. You guys had evidence? Best evidence rule? Yeah. If it's a U.S. agreement, you must use the best official source. Come talk to me. If you need that, come talk to if you're not here, come talk to a librarian. We can point you to the best official source. It's not always as obvious as you think. For non-U.S. agreements, you have to go into chambers and have the judge approve it. That can be a challenge with some judges. Just saying. First question, do I have a citation? If yes, hey, you're in luck, you can find it. Ask the librarian if you don't recognize the sources in the citation. They're going to be a little weird sometimes, especially if it's foreign law. If it's a UNTS, United Nations Treaty Series, or League of Nations Treaty Series, it's pretty easy. OAS, EU, the Council of Europe, the African Union, they all have their own treaty series. We publish treaties in the U.S. and the United States Treaty Series, which is a blue set of volumes. Statutes at large. Treaties were originally published in the U.S. in statutes at large because under Article 6 of the Constitution, treaties and statutes have the same weight. And it was also a publication that they were producing. Something called the Revised Statutes of the United States was published every few years, and that's where they would put them. It was a way of getting them out. There's also the Treaties and International Agreements series, which is currently the current way you find all treaties. The old Executive Agreement series and the old Treaty series. If you see those, you're in luck. If you don't have a citation, is the U.S. a party? The U.S. is a party? Yay! We have all the U.S. treaty tools. We're a U.S. law school, U.S. law library. Everything's fine. No, you get to use the UN tools, which can be okay. You can use treaty tools of the state's party. This is useful if you speak the language of the state's party, one of the state's party. I know this is going to come as a shock. Not everybody does everything in English. When I do foreign law, when I talk about foreign law, it's amazing the number of people who think that legislatures of foreign countries should legislate in English, and they get really upset. Some people, when, Turkey didn't put its family law in English. I'm sorry, but that's not the way the world works. Even if you don't understand the language, you can still usually find stuff using Google Translate to sort of translate things on the page. If you know some keywords about what you're looking about, the timing, and who, you can usually find it. But here's the thing, if it's a bilateral treaty between two countries that don't speak English, it's not going to be in English. You're going to need somebody to translate it. You can use treaty indexes, such as they are, and you can just Google for a site. You know, if it's a treaty that a lot of people have used, all reviews are kind of cite to it. Just saying, you know, it's a good place to, when I need something really quick that I don't have time to go through all the indexes, one of the first things I do is just look for the name of the treaty to see if somebody has cited it, and that gives you clues on how you can find it. Of course, you would never use that citation without checking the treaty, right? Never. No one has ever done that. And you really shouldn't. But it's a good way to at least get a clue as to where you're looking. Third question, is the treaty in force? Yes, that's good. It's easier to find. You can use an index like treaties in force. If it's not yet, you find the sponsors and look at their resources. Right? You know, if it's being sponsored by the United Nations, you can go to the UN and find copies. You can use Google. If it's no longer in force, you get to use historical tools. We'll talk about those. Historical tools require the books. I mean, it's one of the few things we actually do have to go to paper for. Treaties in Force, a fine publication put out by the United States Department of State. It is no longer put out in print. At least I don't think it is. They stopped printing it. For a long time, this was actually, until an embarrassingly recent time, this was kept up to date on file cards in a file box at the Office of the Treaty Advisor. Because you think you have to understand about the State Department, it's the smallest federal agency. And the Treaty Department is the bottom of the trickle down of money. Because, you know, they've got things like, you know, embassy security and, you know, threatening ambassadors, I guess. There's all kinds of things that they have above, right, that are more important than publishing treaties. It's anything to do with treaties. So it took a long time to get this updated, but it's now fairly good. It's on the State Department website. It's on Hein Online. It's not easy to use because it's a gigantic PDF. We're hoping that they will actually, you know, turn it in. If they have it in a database, we're hoping that they put the database up so that people can use it. But no, right now it's a huge, like 600-page PDF, which is just as much fun as you might think to use. You can also go to the Trade Rep's website for the things that are on the Trade Rep website. Hein Online has one of its libraries, and most people you've used Hein Online, you've used the Law Journal Library. There are other libraries attached that we subscribe to. One of them is the U.S. Treaties and Agreements Library. All the old tools are on there in PDF as well. And there's a lot of stuff on there. You can usually find it. And Treaties in Force is there. Okay, the UN treaty tools. The UN Treaty Collection, which used to be, for years I used it as my example of the world's worst website, because it really was. Because you go to the UN treaty website trying to find, you know, a treaty, and it would take, I think the quickest I ever found where a search screen was about 8 clicks in, and it was always links at the very bottom, because everybody in the UN wanted real estate on the front pages, and so you couldn't, even on the treaty website, so you couldn't, it was really hard to find them. Now it's much easier. Pops up, it's treaty.un. It's official. It has a really good index. You can search by party. You can search by words in the treaty. Again, if it's not a treaty that's in English, English words are not going to help you. It's also available for the League of Nations Treaty Service. I went back and did those. The main thing I like about this website, the thing I love about it actually, is the status of multilateral treaties deposited with the Secretary General. There are about 500 and some odd, I think it's like 520 now, 530, something like that. Treaties that are deposited with the Secretary General. Remember we said treaty depositories? Well, these are the ones that are deposited with the UN. And they keep records on all of them. And those records are all available on here. The treaties are broken down by subject matter. They give you all kinds of information. Oh, 560 treaties. I did update my slides. Includes treaties deposited with the League of Nations and some others. For you, it gives you some really important information. Who the parties are, when they signed it, when they ratified it, when it went into force for them. That's really important. Also, every time a country signs onto a treaty, or most times, they append reservations and declarations. They're really hard to find any other place. For the 560 UN ones, they're all on this website. And they're all officially translated into English, because we're using the English version of this. Actually, they're officially translated into all the official languages of the UN. You can get this in any of the official languages. Really useful. It's the only place you can find it. Okay, other international organizations. The OAS has a not so much fun treaties website. I spend a lot of time pounding my head on that one. Council of Europe has a good one. The EU has a decent one. The African Union has a wonderful one, because until they came along, you could not get African Union treaties. They were really hard to find because nobody collected them in this country other than the Library of Congress. The ICRC, International Committee of the Red Cross, if you're doing anything with law of war, they have them all. The International Labor Organization, anything to do with workers' rights, there are hundreds of ILO treaties. They're one of the oldest international organizations. And their stuff is all on there. And they also have IOLEX, which is labor laws from various countries. So it's a wonderful source. The World Trade Organization has all the GATT stuff. They all have treaty series. They're all usable. Foreign state treaty sources. The Foreign and Commonwealth Office of the UK is their treaty office. Wonderful, easy to use. You usually need to use the official language. Leisure France has everything French. I mean, everything in France is legally, governmentally is on Leisure France. It's easy to use if you speak French. The Swiss do it in 3 languages, and they're all, from what I've been told, equally good. I can only use the French one. But I've been told the German and the Italian ones are quite good. Easy to find stuff. Unofficial and historical sources. This is one of the paper ones. The Consolidated Treaty Series. This goes from 1648 to the beginning of the League of Nations Treaty Series. So it's all the older treaties. You'll find them here if they're available. If you need to use this, come find me. I'll help you. The indexes are not easy to use. But it's everything from the 2 treaties that constituted the Peace of Westphalia to the present, or to World War I. Avalon at Yale has a lot of old sources. U.S. Institute of Peace has a lot of peace treaties, historical peace treaties. The Flair Index to multilateral treaties can be a useful source, sort of a Hail Mary kind of thing. See if you can find something. And then there are lots of obscure print collections. You need to come talk to me about those, because some of them are really obscure, like secret treaties from between the wars, that kind of thing. Okay, let's talk about UN docs. The UN. Simplified. Each of these organs publishes stuff. They publish a lot of stuff. There is a system. It's the official document system. It has every document, in scare quotes, from 1993 to the present. And actually, it has a lot going further back. All the resolutions going back to the beginning for all the main bodies. It's got all the human rights documents, I think, at this point. At this point, I'm having trouble finding a human rights document that isn't on here. So they are going back. They just haven't announced it yet. It's fairly simple to use if you're crazy. It is logical. It is extremely logical, and that's the problem. It's also very arcane, because they assume that since they've been living in the UN document system their entire lives, that you all have too. It doesn't work that way. If you can't find something quickly, ask either me or Bill Ryan, who's the other international law librarian. We have literally been doing this for 40 years. There are some tricks. Okay, let's start talking about, we finished treaties. Let's go to custom. Quickly, because I'm running out of time. A norm is customary if it is derived from the general practice of states and is followed from a sense of legal obligation, binding sense of legal obligation, opinio juris sive necessitatis, or just opinio juris, because that's the way Americans say it. Remember what we said about Latin? There is a lot of Latin in custom. Don't be afraid to ask. I have a list on the International Court's website, just /Latin, with things that have come up. I put them up there with translations. So what is general practice? How many states do you need? Well, what is general practice? It means it's been practiced around, right? In a lot of countries, it's a general practice around the world. How many states do you need? Well, according to the ICJ, you need 2 to have practice. The rites of passage case, rite of passage case between India and Portugal. 2 states. And that's a regional custom. For general custom, you have generally, when you're looking at a regional or general custom, you look at a variety. You look at how many states are, like, is it spread geographically around the world? States all over the place, unless if it's something that like only deals with, say, water right, ocean rights. Is it at least all the riparian states? You know, the states that have coastlines. It's like a coastline treaty. If it's, do you have a legal system diversity? Do you have common law systems, civil law systems, traditional law systems, socialist systems, and all the different legal systems? Are they well represented? That's the kind of thing you're looking for. Wealthy countries, non-wealthy countries, powerful countries, great powers, non-great powers. For regional custom, it's just the kind of customs in the countries in the region. You need at least 2. So what constitutes the opinio juris? Oop, I thought I had more note on that. It's an opinion that you think you need to be bound. Right? You're following this. You've stated you're following it because you think it's the law. It's not enough to say we're just going along. You have to have, there has to be some source for that. Usually, opinio juris is done, you look for it in statements of foreign ministries, statements of presidents, leaders. Court decisions can be a good secondary source for it, where like the opinion of the United States Supreme Court is, this is a customary international norm. That's evidence, and that's where you look. Are all states bound? There are 2 theories. Consuetudo, which means everybody's bound. If once we decide that this is general custom, everybody is bound. Unless there's some exceptions that everybody is bound. It's an opt-out policy. Everybody's in, you have to opt out. There's also pactum tacitum, which is a different theory. It was one, actually it's the Russian theory, that you have to be bound. You have to affirmatively agree. Right? You have to say, this is something that we follow. The ICJ sort of split it down the middle. Their opinion in asylum cases is that general practice, general international practice all around the world is consuetudo. Everybody's in unless they say they're out as a persistent objector. Regional law, because it has fewer numbers, you have to opt in. You have to agree to it automatically. You have to be a part of it. There has to be some evidence that you wanted to have this apply to you. Okay. The consuetudo argument, general custom, you're bound unless you're a persistent objector. You just have to persistently object over and over again. The United States does this a lot. We constantly say, nope, nope, nope. And we do that for reasons, because we want to establish that we are a persistent objector to a particular customary norm. We also do things like send ships into the Black Sea to let them know that, no, this is still an international strait, that kind of thing. It's all the same type. Some norms you can't derogate. You can't be a persistent objector to. Use Kogan's norms are those norms. They're peremptory norms of general international law that cannot be derogated. Not everybody thinks they exist. The official position of the United States government is that they do not exist. Every international lawyer I know deals in there thinks that they exist. So, treaty provisions that violate Jus Cogens norms are invalid, which is actually probably the most important thing about them. Things like piracy, not the piracy, the anti-piracy, anti-slavery, genocide is a big one, and you get into once you get past those 3, you get a lot of disagreement as to what is or isn't, and the number of law review articles written on whether something is or isn't a Jus Cogens norm is amazing. Okay, now let's move to the third source, general principles. These are no one ever uses them in law school practice. There are many different levels. Not everybody agrees with what each of these are. The basic one is it's a principle of municipal law applied to a whole, a lacunae. This is from civil law. In civil law, if the legislature hasn't legislated, there's no law. So a judge who's faced with that situation says, no, there's a hole in the law here, and you have to go back to the legislature to fill it. I can't decide this case. The judge declares it non-liquid, which means there's no law, in effect, for this lacunae, and it gets kicked back down. The international system is similar. It's based basically on the civil law system, except there's no legislature. So there are lots of holes. And they decided when they were putting together this theory of international law that judges needed to be able to fill those holes, but they didn't want to give judges power. They didn't want it to be a common law system. So what they said was, if you can show a domestic law, say something in your legal system, like a contract principle, a basic contract principle, that's in your legal system, and it's in the civil law system, and it's in the Russian. So you've got a widespread, it's fairly widespread in all the different legal systems, and it's a general principle, then that becomes one. That's the first type of general principle. The second type are things that have their origin directly in international relations. Things that come out of the Middle Ages, a lot of West Mercantilis, and Ius Gentium and Ius Infinitentis. There's a bunch of those. I won't go into them because it would take too long. The basic ones are sovereign equality and the immunity of states. Those are the big ones that when anybody talks about, that's really what they're talking about. Then there are principles recognized in all kinds of legal relations, regardless of which legal order they belong to. And this principle is, well, legal relations in organized societies. Pacta sunt servanda. If you agree to something, you agree to be bound, you will uphold your bargain. Right? That's basic to the international legal system. That's a general principle of law. The obligation to negotiate in good faith. That's an obligation, a general principle. And there's some other ones, but those are the two big ones that almost everyone agrees on. Then there are principles of legal logic. Example, the idea that a use Kogan's norm trumps a conflicting treaty norm. That's a logical principle. Or, you guys ever heard of lex specialis? It's an international norm that says specialized law that's specific to a topic is more valid, has a higher level than a general law that sort of covers it. So if you've got a specific area of law, that specific norm will trump. That's a principle of legal logic. Okay. And then there are principles of general international law that no one really agrees to anymore as norms, as binding norms. Everybody agrees that self-determination is important, but whether or not it's binding is up to the right to be free of imperialist oppression. One of my favorites. Not very well accepted. Okay, finally, this is the last slide. Remember, a norm can be a treaty, a customary norm, or a general principle norm, all at the same time, or not at all. You can have mix or match. So if you're trying to prove, you're trying to hold a country accountable for something, and there's a treaty provision that's ideal, that shows exactly what you want, but they're not a party to the treaty, there's a possibility that that treaty has codified existing customary international law. And if you can prove that it's a codification of customary international law, then that country is bound unless there are persistent objectors. So that's why that's important. Any questions? Have I put you all to sleep?
So, that's, please help yourself to more than pizza. There's a lot, so guys, please. So that's a ton of information. This is the second time I've watched this and I'm still learning new things, which would have been helpful last semester, but here we are.
And come find me.
Yeah, so does anybody,
Please.
Unfortunately, I don't think we have that much time to go through like a full hypo, but does anybody have like an issue that they've run across that they might want to like pose as an example, or do you guys have questions for Professor Heywood based on slides?
Yeah.
Well, where do we find you?
Oh, easy. Second floor of the library, along the back wall.
Okay.
There's all of our offices are along that wall. It's like in that far back corner over there. We're also, I occasionally have desk hours. I'm supposed to be more than I It's actually kind of hard to find me this year and next year. I'm the faculty senate vice chair for the university, and next year I'm the chair of the senate, and I'm on the board of trustees. And the amount of work, I had no idea. And so, like, I'm not here tomorrow or the next day because it's the board of trustees meeting. But if you send me an email, I'm Heywood, Heywood, at WCL or at American. Either one will get to me. Send me an email. I do try to respond within 24 hours. Grab me in the hallway, and when I'm sitting there, just if my door is open, I'm in 216. If my door is open, I'm available. So you're not interrupting me. And if you keep me out of a meeting, this right here is keeping me out of a meeting on main campus right now. I'll be forever in your debt. Yeah.
When do you teach your class?
I haven't taught it in 2 years because I can't. We put it on the schedule and it doesn't make. So I keep trying. Hopefully I'll teach it next year. It's international courts. It's a survey. It started off as basically just the ICJ back in 1990, and then the criminal courts blew up, and so now it's a survey class of all the international. It's basically international dispute resolution from a judicial side. I'm trying to get them to not cancel it until after ad drop, because we get half my classes LLMs, and they don't get here until the summer, and they don't get here till it's after. They don't send it for their classes until after the kill date has gone by. So I just have the JDs. That's not enough. But I will try again. Keep trying.
Anyone else have questions? Well, thank you so much. We really appreciate you coming and doing this presentation.
And you guys are doing like notes or art papers and stuff. Talk to me early. Now, how many of you are 2L? Other 2L? Has anybody here not done their upper level yet? Okay. Come talk to me if it's international. I can get you point you in directions. I like doing that.
Please, have your key on the way.